A new Illinois law that will go into effect on January 1st, 2025 is a new requirement that landlords disclose potential flood risks to tenants that they are leasing to. If a landlord fails to make this disclosure, a tenant may be given rights to terminate the lease and seek damages against the landlord if the property is flooded or a required disclosure is not made. Now, in some ways this makes sense, as if there's some damage to the property that causes it to become uninhabitable, generally already a tenant would have some avenues to get out of the lease, or at least the remainder of the lease. But it's important to keep in mind that this specific law will give the tenant similar rights if a disclosure of a potential risk is not made before the tenant moves in or when the lease is signed. The rights a tenant may be given if this occurs is a right to terminate the lease if the tenant gives notice to the landlord within 30 days of flooding on the property, and if the lease is terminated in such a manner, the tenant may also recoup damages, including any prepaid rent and the security deposit, and have a claim for damages to the property that they incurred. So what needs to be in the disclosure? The statute itself sets out a basic form of standard language to be used, and I expect that we will put forth an example of that in the coming weeks and months on our website. And essentially what the disclosure says is whether the property that the tenant is leasing sits on a 100-year floodplain or if it has a known history of flooding on the property.